A man is pulled over on a quiet road just after sunset. The lights flash behind him, red and blue cutting through the darkness. He pulls over, heart racing, but calm enough. He's done nothing wrong. At least, he thinks he hasn't. The officer walks up. Calm voice, friendly tone. Then, without warning, the officer places a hand on the car, and everything changes. Not loudly, not dramatically, but legally, that moment matters more than most people realize. Because what happens next could determine whether your rights stay intact or quietly disappear without you even noticing. Have you ever wondered what you would actually say in that exact moment if a police officer touched your car during a stop? Tell me in the comments, what would your instinct be? Because most people get this wrong, and not just a little wrong, but in a way that can permanently affect their legal protection. And here's what most people don't realize. That simple act, an officer touching your car, is not just casual behavior. In many cases, it's a signal, a legal step, sometimes even the beginning of a search. And if you don't respond correctly in that exact moment, you may unknowingly give away protections that courts have spent decades defining. But before we get into what you should say, you need to understand what's really happening beneath the surface. Because what looks like a routine traffic stop is often a carefully controlled legal environment. And this is where things take a turn. Under U.S. law, traffic stops are considered seizures under the Fourth Amendment to the United States Constitution. That means the moment those lights turn on, your rights are already in play. But not all rights operate equally in that moment. Some are active, some are limited, and some depend entirely on what you say or don't say. Now imagine this. The officer places their hand on your car. Maybe it seems harmless. Maybe it feels routine. But courts have generally held that officers may use touch as a way to establish contact, leave fingerprints, or even subtly check for hidden threats. In many cases, it's also used to confirm that the vehicle is physically present and to create a record of interaction. But here's what most drivers miss. That touch can sometimes coincide with the beginning of what's called a plain view or plain touch observation. And that's where things become legally sensitive. Because if, during that interaction, the officer claims to observe something suspicious, the situation can escalate quickly. And what happens next shocks most drivers. Because at that point, your response, your exact words, can determine whether a search becomes lawful or challengeable. Now here's the part nobody tells you. You don't need to argue, you don't need to resist, and you definitely don't need to escalate. In fact, doing those things can make your situation worse. But you do need to say something, calmly, clearly, and legally precise. And here's what experienced defense attorneys consistently recommend in many situations. I do not consent to any searches. That's it. Simple, direct, controlled. But here's why that matters more than you think. Because under U.S. law, consent is one of the most powerful tools law enforcement can rely on. Courts have generally held that if you give consent, even casually, even unintentionally, you may waive your Fourth Amendment protections. And the key word here is waive. Not temporarily, not conditionally, but completely in that moment. So when an officer touches your car and begins observing and possibly probing, if you remain silent, courts may interpret your behavior in different ways depending on context. If you appear cooperative, if you nod, if you open the door, if you say something like, "Go ahead," that can be interpreted as consent. And once consent is given, challenging that search later becomes extremely difficult. But here's what most people don't realize. You don't have to give consent. You have the right to refuse. And that refusal, when done respectfully, is fully protected. Now here's where things get even more interesting. Saying, "I do not consent to any searches," does not mean the officer will stop. And this is where many people get confused. Because your statement does not physically prevent the officer from acting, but it does something much more important. It preserves your legal position. In many cases, if a search occurs without consent and without proper legal justification, courts may later determine that the evidence obtained is inadmissible. This principle has been reinforced in cases like Mapp versus Ohio, where the U.S. Supreme Court established that evidence obtained in violation of the Fourth Amendment cannot be used in court. But here's the catch. If you gave consent, even unknowingly, that protection may disappear. And this is where things take another turn. Because officers are trained to communicate in ways that feel non-threatening, they may say things like, "Mind if I take a quick look? Just want to check something real quick. It'll only take a second." And in that moment, under pressure, many people respond instinctively. They say yes, they nod, they step out, they open doors, and without realizing it, they've just changed the entire legal framework of the encounter. Now let's pause for a second. Think about that. One word, one gesture, and everything shifts. But here's what most people don't realize. You can be polite and still protect your rights. You can be calm and still be firm. You can cooperate without consenting. And this is the balance that experienced legal professionals emphasize, because escalation helps no one. But silence alone is not always enough. And this is where that one sentence becomes powerful. I do not consent to any searches. It creates a clear record. It removes ambiguity. It signals awareness. And it preserves your legal standing. Now you might be wondering, what if the officer insists anyway? What if they say they have probable cause? What if they proceed regardless? And this is where things become even more nuanced. Under U.S. law, officers may conduct a search without consent if they have probable cause or under certain exceptions. These include situations involving officer safety, evidence preservation, or visible contraband. Cases like Arizona versus Gant have clarified the limits of vehicle searches, especially after arrests. But here's the critical point. Whether the search is lawful or not is often determined later, not on the roadside, not in that moment, but in court. And what you say or don't say becomes part of that evaluation. Now imagine two scenarios. In one, the driver says nothing, stays quiet, complies silently. In another, the driver calmly states, "I do not consent to any searches." Same situation, same officer, same outcome in the moment, but legally, very different positions. Because one creates clarity, the other leaves room for interpretation. And in legal contexts, interpretation can be everything. But here's something even deeper. This isn't about confrontation. This isn't about winning against law enforcement. This is about understanding your role, your rights, and your boundaries. Because when people panic, they either overreact or they surrender control completely, and both can lead to consequences. But controlled awareness? That's different. That's powerful. And this is where things come full circle. That moment, when the officer touches your car, is not just physical contact. It's a signal, a transition point, a moment where the interaction can go in multiple directions. And your response can shape that direction. Not by force, not by resistance, but by clarity. And here's what most people don't realize until it's too late. You don't get a second chance to set the tone of that interaction. The first words matter. The first response matters. The first signal matters. Because once things escalate, it becomes much harder to regain control. Now let me ask you something again. If that moment happened tonight, if those lights came on, if that hand touched your car, would you know exactly what to say, or would you rely on instinct? Because instinct, under pressure, is often unreliable. But preparation? That changes everything. And this is why understanding this one phrase, this one moment, can make a difference. Not just legally, but psychologically. Because when you know what to say, you stay calm, you stay grounded, you stay in control. And that alone can shift the entire interaction. Now here's the final piece most people overlook. Respect matters. Tone matters. Delivery matters. Saying, "I do not consent to any searches" should never be aggressive, never confrontational, never sarcastic. It should be calm, neutral, clear. Because the goal is not to provoke. The goal is to preserve. And when done correctly, it does exactly that. So the next time you see those lights, the next time an officer approaches, the next time that hand touches your car, you won't be guessing, you won't be reacting, you'll be ready. And that readiness can make all the difference. If this opened your eyes, subscribe for more content like this, and share this with someone who needs to understand their rights before they find themselves in that moment with no idea what to say. Because here's what almost no one talks about. That moment doesn't end with what you say. It begins there. And what happens in the next 30 seconds can either reinforce your protection or quietly undo it. Imagine this. You've just said calmly, "I do not consent to any searches." The officer pauses. There's a shift, subtle, almost invisible, but it's there. And this is where most people make their second mistake. They get nervous. They start talking. They try to explain themselves. They add extra words like, I don't mind, I just... And just like that, the clarity they created begins to dissolve. Because in many cases, consent doesn't have to be loud. It doesn't have to be explicit. Courts have generally held that consent can be inferred from behavior, tone, and context. So if your words are firm, but your actions are uncertain, that contradiction can be used against you. And this is where things take another turn, because what you do physically matters just as much as what you say verbally. If you say you don't consent, but then unlock your doors, if you say you don't consent, but then step out and gesture toward the vehicle, if you say you don't consent, but then open your trunk, that mixed signal can weaken your position. And what happens next surprises most drivers, because from a legal perspective, those actions can be interpreted as implied consent, not because you intended it, but because your behavior suggested cooperation beyond simple compliance. Now here's the distinction that changes everything. There is a difference between compliance and consent. Compliance means following lawful orders, stepping out of the vehicle if instructed, providing identification when required, keeping your hands visible. Those are generally expected behaviors during a traffic stop. But consent? That's voluntary. That's optional. That's something you have the right to refuse. And understanding that difference is where control begins. But here's what most people don't realize. Officers are trained to navigate that line. Not illegally, not improperly, but effectively. They know how to ask questions in a way that feels casual. They know how to create an atmosphere where saying yes feels easier than saying no. And under pressure, most people default to ease, not strategy. And this is where things can quietly escalate. Because once a search begins, especially with consent, the legal path becomes much harder to challenge. Now you might be wondering, what if the officer never asks? What if they just continue touching the car, looking inside, walking around? And this is where awareness becomes critical, because not every search begins with a question. Some begin with observation. Others begin with what's legally known as a protective sweep. Under certain circumstances, officers may briefly check areas of a vehicle if they believe there's a potential threat. This concept has roots in cases like Michigan versus Long, where the Supreme Court allowed limited searches of a vehicle for weapons if officers reasonably believe their safety is at risk. But here's the key word: reasonably. Not vaguely, not automatically, but based on specific, articulable facts. And this is where things become complex, because what qualifies as reasonable can vary depending on the situation, time of day, location, behavior, context. All of these factors can influence how an interaction is interpreted, and this is why your behavior matters so much. Because even small actions, like sudden movements, reaching into compartments, or appearing overly nervous, can shape that perception. Now let's slow this down for a moment. Picture yourself in that situation again. The officer has touched your car. You've stated clearly that you do not consent to any searches. Now what? This is where discipline comes in. You remain still. You keep your hands visible. You avoid sudden movements. You respond to direct questions, but you don't volunteer extra information. And here's what most people don't realize. You are not required to answer every question. In many cases, you must provide identification and basic information during a lawful stop. But beyond that, your right to remain silent still exists. And that right has been reinforced through cases like Miranda versus Arizona. But here's where things get subtle. The roadside is not the same as an interrogation room. Miranda warnings are typically required when you are in custody and being interrogated. A traffic stop, at least initially, is considered temporary detention. So officers may ask questions without reading those rights, and many people answer them without realizing the implications. Questions like, where are you coming from? Where are you headed? Is there anything illegal in the vehicle? They seem harmless, routine, even polite. But here's what most people don't realize. Your answers can be used to build a narrative, a timeline, a justification. And inconsistencies, even small ones, can raise suspicion. So what do? You stay calm, you stay respectful. And if you choose not to answer certain questions, you can say something simple like, I prefer not to answer any questions. No hostility, no attitude, just clarity. Because again, this isn't about confrontation, it's about control. And this is where things take another turn, because the longer the stop continues, the more pressure builds. And what happens next catches many people off guard. An officer might ask you to step out of the vehicle. Now here's something important. Under U.S. law, courts have generally held that officers can order drivers, and even passengers, to exit the vehicle during a lawful traffic stop. This principle was established in cases like Pennsylvania versus Mims and later extended in Maryland versus Wilson. So if you're asked to step out, you comply. Because that's not consent. That's a lawful order. But here's where people get confused. Once they're outside the vehicle, they feel exposed, uncertain, more vulnerable. And in that state, they become more likely to agree to things they normally wouldn't. And this is where awareness becomes your anchor. You've already stated you do not consent to searches. That position doesn't change just because you're outside the car. It stays with you, consistent, clear, and legally relevant. Now imagine this next moment. The officer begins walking around your vehicle, looking through the windows, shining a light inside, maybe even pausing at certain points. This is often referred to as a visual inspection, and in many cases, it's allowed, because anything in plain view can be observed without a warrant. But here's where things shift again. If the officer claims to see something suspicious, that can become the basis for probable cause. And once probable cause exists, the legal threshold changes, because under what's known as the automobile exception, officers may search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. This doctrine has been shaped by cases like Carroll v. United States. But here's the nuance. Probable cause is not arbitrary. It must be based on observable facts, not assumptions, not guesses. And this is where your earlier statement, your refusal to consent, continues to matter. Because if a search is later challenged, the presence or absence of consent becomes a critical factor. Now let's step back for a second. Everything we've talked about so far, it's not about memorizing lines. It's not about rehearsing a script. It's about understanding the structure of the interaction, the flow, the turning points. Because once you see those patterns, you don't panic. You recognize what's happening, and that recognition gives you control. But here's one final layer that most people never consider. Documentation. Not in the moment, but afterward. Because if something feels off, if you believe your rights were violated, what you remember and how you record it can matter. Time, location, officer behavior, sequence of events, these details can become important if legal questions arise later. And this is where everything connects. Your words, your actions, your awareness, they don't just affect the moment, they shape what comes after. And that's the part most people never see coming, because by the time they realize what happened, it's already too late to change it. So let me ask you again, now that you understand how quickly things can shift, now that you see how one moment can influence everything that follows, would you handle that situation differently? Would you stay silent? Would you speak up? Would you recognize the signals? Because the difference between confusion and clarity often comes down to preparation. And now you have it. If this made you think differently about something you've experienced or might experience, subscribe for more. And share this with someone who believes a traffic stop is just routine. Because sometimes, the smallest moments carry the biggest consequences.